Hi, everyone. So for this evening's last topic, I'm going to talk about the controversial new business model that's emerged in the online advertising space, which is known as consent or pay. So this is the model that Meta launched in November for its Facebook and Instagram platforms in the European Union. The EDPB has been kind enough to publish their opinion on this model just in time for my talk this evening, so I can give you an update on the latest development in the EU regulators' objections to behavioural advertising. I should say that the opinion was triggered by Meta rolling out consent or pay, but it's not specific to any one company. It's not specific to Meta. So they say it applies to all large online platforms, which they not so helpfully don't define, but it probably is going to be significant to a lot of the companies on the screen. So just before I go into the opinion itself, just a quick look at the business model. You'll all be very familiar with this. So the bargain that is struck with users of a free online platform is that all the users get to use it and that service is free of charge. And then on the other side of this, the platforms fund themselves by getting paid quite a lot of money by advertisers who like to serve their ads on the platform so that they can be personalized to users. So this involves behavioral advertising, so collecting user activity in what you do, what you click on, what you have your thumbs up, Facebook like on, so that ads can be made to shown more relevant to you. So simple example, my wife's joined a lot of new mum groups on Facebook recently, so she gets loads and loads of adverts for little baby clothes, and she loves it. And I now have to buy a new wardrobe for the nursery. So yeah, this is the bargain. What's the problem? EU regulators just don't like it. And they say in this new opinion, but also in lots of decisions before it, some of the reasons why. They say it's complex, which in and of itself shouldn't necessarily be a bad thing, but I think they're getting it. It's a bit of a black box. Not everyone knows how all these algorithms work. It's done on a massive scale, so global, very large online platforms. Then it gets perhaps a little bit hyperbolic when they say, it's so intrusive that it's potentially monitoring your entire life on and offline. Well, I mean, it's all about online activity, and I think really what's maybe a better way of putting it, as we've all maybe experienced, is sometimes adverts seem just a little bit too relevant to you. Some people like that, some people don't. I think a lot of people just accept it as part and parcel of using services for free. But I mean, however you personally feel about behavioural ads, EU regulators face this dilemma that the GDPR does not specifically prohibit it. So what is a regulator to do? So they've been challenging it basically by contesting the GDPR legal basis on which processing that results in behavioural advertisement serving is conducted. Back in December 2022, contractual necessity was ruled out. And so then Meta had to change to legitimate interest as the next basis to rely upon. And in that case, Bundeskartellamt that Mac was talking about, they also said you probably can't rely on legitimate interests for certain types of behavioural advertising. And then we come to November when there was another European decision confirming that they can't rely on contractual necessity, you can't rely on legitimate interests to serve behavioural advertising. So really that only leaves one viable legal basis left, which is consent. So come November, that's when, just in the EU, so that's why UK hasn't been affected, Meta said, well, here's a compromise then. Let's give the users the choice. They can either consent to personalized ads and continue to use the services for free, or pay a fee, which is reasonably normal for a tech company service, around €10 a month, and then they'll receive no ads at all. If you've been following, you can probably guess what the EDPB thought about this. They still don't like behavioural ads. In this new opinion, they reached the conclusion that in most cases, they don't think it's going to be possible for a large online platform to rely on consent under the GDPR, where there's only this binary choice if you consent to all ads or you pay. And this was for two main reasons. The first, basically on a strict interpretation of the requirements for consent under the GDPR. So the first one was freely given. And I think here, because users are being given a choice, they had to get a bit creative. And so there's a lot of quite emotional argument about how social media platforms are so important for everyone's life that there's no real practical option not to use them. And maybe not even use a competitor, even though there are competitor platforms. Maybe you're so attached to your particular one that there's no option but to use it. It could be vital for your social life, for your access to information, and with quite an implicit nod to LinkedIn, for your professional lives. Maybe you can't get a job without LinkedIn. So they're basically equating it to some sort of essential service. And they say this creates an imbalance of power issue, so that consent is unlikely to be meeting the freely given requirement. And in a similar way, consent should be possible to refuse without detriment. And they say, well, not using such an essential platform is a detriment. Paying money, that's a detriment. So consent is unlikely to be valid. But then this does, of course, raise the question, well, if platforms are essential and still need to be provided for free, but you're going to take away that big personalized advertising funding model, then how is this going to work? How is anything going to be run as a viable commercial business? So the EDPB did have a solution to that as well. They use a slightly strange analogy for this. They say, well, the consent option is basically using the platform for free, but you're nakedly exposing all of your data to a controller so they can personalize ads towards you. This is the naked option. The other option given is you can be fully clothed and protected and not exposed to the data processing that they object to, but you have to pay for it. And so they're saying it's unlikely that GDPR consent is going to be valid if you're a large online platform with that imbalance of power. So they say you should, they don't go as far as to say must, but you should at least consider, if you're a large online platform, offering a FORBA, which is a free alternative without behavioral ads. So this is, this is basically just saying it could be a contextual ad or it could be a general ad as this option that you wouldn't have to pay for. So this sounds perhaps a good compromise, but it doesn't really recognize certain business realities. So, the offer of a FORBA is going to take away all that reason that advertisers like to use social media platforms. They like the nuanced targeting and they like the effectiveness of it, and that's why they're paying the funding. So that funding is probably going to drop away a lot if this is done by large online platforms. It's also a little bit hard to envisage how contextual ads alone could work on certain types of platforms like social media platforms because they have billions of users every day posting lots of very different types of content. So it's not really as straightforward as, say, showing an advert for a mortgage on the FT website or showing an ad for a fantasy video game in an ad break for Game of Thrones. It's much more complex, which is how the behavioral advertising model has been wrapped around social media platforms in the first place. So finally, this just brings us to some key issues with the opinion. You get the sense in reading it that the EDPB might be a bit unsure themselves about the global economic implications of this opinion. So there's a lot of caveats throughout. Everything is a case-by-case basis, so the National Data Protection Authority should always be considering on the facts. It might apply, it might not. They don't define large, so there's a question of which platforms are going to be in scope. There's going to be a question about what makes a platform so important that there's no real practical option not to use it or to use a competitor. Aren't other competing platforms relevant? And quite tellingly, the opinion doesn't really seem to properly consider that under the Charter of Fundamental Rights of the European Union, you do have these privacy rights, but you also have a freedom for a company so have the freedom to conduct its business. And so you're meant to balance these rights proportionately, which doesn't seem to be done at all in the opinion. We talked about commercial viability. How are these large online platforms going to make up the significant loss of funding? So maybe it just raises more questions than it seeks to answer, this opinion. And I think if interpreted too enthusiastically by certain national regulators, EU users might find that instead of paying for no ads, they might just have to pay for some new premium versions of lots of different platforms that are currently free to them today, to make up this ad funding shortfall that could result. Because as we all know, there's no such thing as a truly free online service. That's it for me. Thanks for listening.